Good afternoon, everyone. Thank you for joining us for today's online talk entitled From Seizure to Prosecution, Caught for Evading Customs Duties. Before we start today's talk, let me introduce the firm and what we do.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Good afternoon, everyone. Thank you for joining us for today's online talk entitled From Seizure to Prosecution, Caught for Evading Customs Duties. My name is Aaron Liu. I am the Senior Associate with Malaysia Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm founded in 1985 by Datuk Ma Wing Kwai. Our able team today consists of 31 lawyers and a support team of 33. Following his retirement from the Court of Appeal in 2015, Datuk Ma now serves as a consultant with the firm. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. Ma Wing Kwai & Associates is a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Now, today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcast live. Due to the COVID-19 MCO period, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute any legal advice. Should you require specific legal advice in relation to your matter, please contact us for a complimentary legal consultation. Further details will be provided at the end of this talk. For today's online talk, we have one speaker. Allow me to introduce our speaker, Ms. Agalia Munusamy. Agalia is our partner in our criminal, customs and logistics, and family and matrimonial teams at Ma Wing Kwai & Associates. She graduated from Aberystwyth University, Wales, and was admitted to the Malaysian bar in 2014. Her areas of practice include criminal law, general litigation, customs advisory, and seizure-related matters. In today's talk, Ms. Agalia will enlighten us on several key issues concerning the evasion of custom duties, including the following: seizure of goods by the Customs Department, criminal prosecution, forfeiture proceedings, and case studies and analysis. After Agalia's talk, we will then conclude with a Q&A session. If you have any questions, please feel free to type them in the Q&A chat box at the bottom. We will address the questions at the end of the sessions. Now, without further ado, I'll hand the session over to Ms. Agalia. Yeah, over to you.
Hi everyone, good afternoon for joining us today, and thank you Aaron for the quick introduction. Yes, as you said, we have many slides to go through today, and it's a 1-hour talk, so let's get to it as soon as we can. So I will start the talk today by taking you through the seizure of goods by the Customs Department. So firstly, before we go into what they can do, we should know what powers do the customs officers have. So in order to do this, we are going to look at the Customs Act 1967, where we can identify that the customs officers have powers to search, power to seize, and power to arrest. In terms of power to search, they have Section 106A provides the customs officers wide range of access. And then you can see Section 107, where you can have arrest search by warrant. And Section 108 provides for search without warrant. So in most situations where I have encountered, a lot of research is usually without warrant, because at the very beginning, if there's already reasonable suspicion, then there's no need for a warrant in customs procedures. So it's as long as they have some sort of reasonable doubt or reasonable suspicion, they can search any premise without any warrant. So once they search the place, what's going to happen? So if they find any goods that does not conform or is not lawful to be there, what happens is they can use Section 114 and the powers under Section 114 of the Customs Act to seize those goods. So once they seize, what they're going to do is usually they will have a search list, or they would say a seizure list. And then there's also provision for them to provide a seizure notice upon seizure being effected. And then finally, once they seize the goods, they're obviously going to arrest the person who is there, or at least the person who assisted or is found to be with the goods at that time. So in terms of powers of arrest, the customs officers have power to arrest pursuant to Section 107(1)(b), which is arrest without warrant. And then there's also Section 116, subsection 1, which is arrest with warrant. As you can see, I have listed some other search powers, search provisions, and arrest provisions, which you can read up on your own, but that is not relevant to our talk today. So moving on, let's go on to what are the goods that can be seized. So under the wide powers provided, or the wide discretion provided under Section 114 of the Customs Act, the customs officers may seize things like goods. So any goods suspected to be involved in an offense or is found to be in breach of any license or permit requirement. So goods can be anything like liquor, beer, cigarettes, most likely. And then we have also had previously, they have also seized medication, because just a fun fact, medication is actually poison unless it falls under Schedule 1 of the Poisons Act. So if you're found to have a lot of medication, it can also be considered poisons. So these are the type of goods that can be seized. Other than that, they can also seize conveyance, which means the vehicle that is used in connection with the offense. A scenario I'd give you is that if someone is transporting huge containers of liquor somewhere, they can seize the entire container and the vehicle or the lorry that is carrying the container on that vehicle, right? So it can be cars, it can be lorries, it can be motorcycle, anything that is in connection with the commission of the offense can be seized. And then they can seize any sort of containers or packaging, which includes boxes, containers, storage units. So one thing is that they do not have powers to seal a premise, but what they can do is they can take out all your stuff from that premise and seize them under a seizure notice. This power is not limited. You can also go on to documents and records. So if they enter, say, a business premise, if they do find unlawful good or uncustomed goods inside the premise, they can also search the premise and take any sort of documentation or records of the incoming of those goods into your premise. So this includes invoices. If you're a forwarding agent, this can also relate to shipping documents like bill of lading, inward manifest, and anything else like a purchase order or an invoice or things like that. And then they can also take your business records and dealings, but only in relation to the goods that were taken from your premises. Okay, now let's move on to the effect of a seizure by the Customs Department. You might be wondering what happens to the goods or the vehicles that have been seized by the Customs Department. The Customs Act is very comprehensive. So basically they give you steps for every single step of the way, and they give you the procedure for every single step of the way. So pursuant to Section 115 of the Customs Act, seized goods are usually placed under the custody and control of Customs Department. So most of the time they have something called a customs warehouse or a customs or a location where they usually keep all of the goods that they seize. For example, if I'm not mistaken, there is one in Port Klang, there is one in Banting, there should be another one which I often see containing cars. There's one in Brickfields, and then you can also find them usually around their buildings. So these goods can be also kept in their premise, as in their wherever you can find Jabatan Custom Diraja Malaysia, they can also be kept there if they are in small quantities. So larger quantities usually have a depot where all these goods are sent there. You may be wondering, if goods have been seized, can they be returned Actually, yes. Pursuant to Section 115, customs may return goods if they have been satisfied that the security for the amount of goods that were taken were paid to their department. And then they can also detain, store, remove, sell, or destroy the goods even. In cases where goods have become part of evidence, wherein there's prosecutions being carried out in the court, most of the goods are usually preserved pending these investigations because they will be used as evidence in trial. Then we have pursuant to Section 126 of the Customs Act, it provides that all seized goods shall be liable to forfeiture. So seized does not mean automatically forfeited to the Customs Department. Seized means it's on temporary hold, which means it's belonging or at least under the control and disposition power of the customs, but it is not yet lawfully forfeited. And then there's also provisions that forfeited goods shall be disposed of according to the direction of the Director General of the Customs. And then we have pursuant to Section 127 of the Customs Act, which provides that only a court can actually order forfeiture of any seized goods. So as I mentioned earlier, not all seized goods are deemed to be forfeited, and if Customs Department wants to forfeit some sort of goods, say a container of liquor, they want to forfeit it. So they do have to apply, they must apply to the court for an order for forfeiture, and then it can only be forfeited if it has been proven that an offense has been committed under the Customs Act. So you're looking at, generally speaking, about goods, but there is a difference. If you go through Section 2 of Customs Act, you will find a differentiation of dutiable goods and goods. So what is the meaning of dutiable and uncustomed? As you can see on the screen, dutiable goods means goods subject to payment of customs duty on which such duty has not yet been paid. Contrarily to uncustomed goods actually means goods in respect of which a breach of the provision of this Act or any subsidiary legislation made thereunder has been committed. So dutiable goods do not actually mean they are goods, and dutiable goods do not in fact mean that any sort of offense has been created or any offense has been committed. But when someone refers to some goods as uncustomed goods, then that definitely means that those are goods subject to an offense that has been committed under the Customs Act. So here are some important key characteristics of dutiable goods, and then later I will go on to uncustomed goods. So basically, as I said, dutiable goods are lawful goods. Duty is payable but not yet settled. So that doesn't mean it's illegal yet, it's unlawful yet, okay? And then these goods, dutiable goods, are still within customs control, which means you can find them at ports, like port. You have Tanjung Pelepas and all these kind of ports. And then you can also find them in warehouse. So warehouses can be either public bonded warehouses or private warehouse, but this still requires some sort of documentation to be taken out of the warehouse. So as you can see, the examples provided, dutiable goods can be imported goods awaiting clearance. This is like those goods that you buy on Shopee or Lazada. They come in from China, so they are not illegal, they are not unlawful, they are just waiting for clearance. As soon as the duty is paid, then you can take it out. Okay, so then you have goods in bonded warehouse, and you also have goods pending duty payment. So this is again what I mean. An example of goods waiting at the airport, they just need the duty to be paid until you can take them out. So these are legal goods, but those involving incompetent compliance. So once legal compliance is observed on these dutiable goods, they become lawfully imported goods. Now let's look at some characteristics of goods. Uncustomed goods are goods in respect of which there has been a violation, such as non-payment of duty, false declaration, goods that have been smuggled, or goods that are in breach of license and permit conditions. Some examples of these are goods that are brought without declaration, goods that have been valued during their importation. So that means some sort of duty is still payable on this amount and they have taken it out without paying this total sum of value of the good. And then there are also goods that are prohibited goods imported without license. So ultimately, uncustomed goods are illegal and unlawful goods that have already entered Malaysia, whether it's by import or by any other means. So if you see the Customs Act as a whole, the Customs Act doesn't tell you anything on what goods can be imported and exported. So you might be wondering, how will I ever know what can be imported and what cannot be imported if it's not stated in the main act, in the Customs Act? So this is where I tell you that you can find these kind of details in a subsidiary legislation called Customs Prohibition of Imports Order 2023. So this order has been in operation since 15th of April 2023, but that doesn't mean it is brand new. What it means is that this list keeps getting updated. So if you want to know a bit of a background, there was one Customs Prohibition of Import Order in 2011, there was one in 2013, there was one in 2015, there was one in 2019, and it keeps updating because more and more goods are being produced, and sometimes law changes on what you can bring in and what you can't bring in. So when we say it's 2023 or if it's updated in a few years, it doesn't mean it's brand new. It just means the list keeps getting updated. So under this Customs Prohibition of Imports Order, you can find details of goods that have been absolutely prohibited from importation, but there's also some category of goods that are under conditional prohibition. So in terms of conditional prohibition, it means there are a few types of conditional prohibition here. So conditional prohibition, except in the manner provided, you have certain class of goods there. And then you have some goods that fall under conditional prohibition, except under import license, and does not apply to specified free zones. So it keeps getting more and more complex. And then there's also conditional prohibition, except under import license, but this applies wholly, does not apply to free zone, or it applies even to free zone. So it's a very comprehensive act with Schedule 1 up to Schedule 3 with various type of goods. It's a really thick document that you have to go through and see what are the type of documents, what are the type of goods, and what are the conditions of import on all of these goods. So now that we know what is uncustomed, what is dutiable, where the offense arises, what you can bring in, what act tells you what you can bring in. Now let's move on to criminal prosecution by the Customs Department. So let's start off with some of the very common offenses that you can find. Maybe you can find it reported in the news. Maybe you can find, you're watching the TV3 news one day and it says, oh, the Customs Department has foiled some plan or some smuggling ring. So these are the kind of the important ones or the most common ones that we can see. So Section 113 provides for the offense of incorrect declarations. So Section 113 provides that a person commits an offense if they make a false declaration. So that includes providing any declaration or document that is untrue or incorrect in any material, in any particular material, or a person commits an offense if they use or submit false documents itself. So not only it's untrue, it's entirely false. So that's like submitting false information to the custom, or they use documents knowing that they are inaccurate in their description. So you might be asking, what is declaration? So I'll just give you a brief explanation. A declaration is a document that you use to declare to the Customs Department. And this is very common to be used by forwarding agents, by import agents, by shipping agents, to make declarations to the Customs Department to tell them, I am bringing in this amount of container, I have this amount of goods inside, and this is what they are and what are their quantities. So why this is important is because if any of those goods are actually dutiable, then duty must be paid on those goods. So why it becomes an offense is because if you underdeclare or you give untrue or incorrect information on the goods, obviously that means the valuation is going to run and it's not going to be correct on the amount or the quantity of things that you bring in. So that makes it an offense. Section 113 also then provides that a person commits an offense if you forge or you falsify documents such as counterfeit or falsifying customs document, or you use and you assist in using of such documents. So you might not be the person who did the falsification, but you might be the person who takes the document and goes to the Customs Department to make a payment on the valuation of those goods. So if they do find like this has happened, then you will fall under this category of persons and it will become this category of the offense. And in terms of incorrect declaration, even tampering with official document is considered incorrect declarations, even if that means it's not a declaration. So you can see the example given here is you alter documents fraudulently. That doesn't mean you're making a declaration, right? Because what I said, a declaration was you are giving a form to the Customs Department to say this is this. So even if you're not giving the declaration, as long as you alter the document fraudulently, it becomes an offense. It doesn't go much to say that even if you forge documents like customs seals, signatures, or trying to impersonate a customs officer in or through a document, that also becomes an offense, obviously. pursuant to section 133. So under section 133, you can see that we have already gone through 4 types of incorrect declarations and we still have more to go. So basically, it's a very comprehensive list on a lot of things that can go wrong when it comes to declarations. So one of it is failure to declare goods, where you bring in goods which are there in the container, but they don't exist anywhere in the description of the goods. So you see, when you import a container, you don't know what is inside the container. You have to go based on the documentation provided to you. So if you do not see the goods and you don't know what you're declaring, you can only go by way of relying on documentation that is provided to you by someone else. You are not even creating the document. But section 113 is such a strict liability offense that even whether or you don't know, it becomes an offense if you fail to declare something that you didn't even know was in the container. So I will give you some case examples later on, and I'll talk about my personal experience on having to deal with this kind of case and how that had impacted, how the law had evolved in terms of this section 133 being a strict liability offense. And then we're moving on to the next one, which is failure to produce required documents. It also becomes an offense of incorrect declaration if you refuse or fail to provide documents when required by the customs office. So commonly where this happens is if you are at the gate of the port and you are going to drive your lorry out, and as you're driving out, they stop you to check your documents, right? Because nobody can clear it out of the port without having their documents checked. So if you refuse or you fail to produce the documents during this stage, you can be charged with an offense for failing to produce required documents. And the final one is failure to comply with declaration procedures, where you do not submit declarations. Say you are a forwarding agent, somebody has sent a container containing maybe cigarette, and the container has been sitting there for 3 months, and you as the appointed agent, you have failed to submit the declaration. So this comes under failure to comply with declaration procedures. Usually there's a timeline between when the goods arrive at the port until when you can do the declaration for the goods. So if you fail to make the declaration within this time limit, an automatic suspicion arises that something is wrong with this container. Why is this person not declaring, although it has been sitting here for 3 months in the port? So these are all things that leads to investigations and can ultimately result in a charge under section 133 or could be section 135, which we'll see later. So now that you know what kind of offenses that can happen under section 133, incorrect declarations, what are the penalties for it? So as given under the same section 133, the penalties can go up to a fine of up to 500,000 or imprisonment up to 7 years or both. So usually in my experience, if you're a first-time offender, it might be just a fine. But if you're a repeat offender, it is highly likely that you can be imprisoned and fined at the same time. So now let's move on to smuggling offenses, which is what you generally hear about customs-related offenses. Section 135 provides for the punishment and for the description of smuggling and evasion of customs duties. So under section 135 subsection 1, a person commits an offense if they knowingly, as you can see here, some of the examples, import and export or prohibited goods. I think you can go through the examples yourself, so I'll just move through quickly. The second one, that is section 135.1a. Section 135.1b refers to ships, unloads, delivers or assists with such goods. Section 135.1c deals with removing goods illegally from customs control. Section 135.1d deals with people who harbor, keep, conceal or possess such goods. So if I'm talking about such goods, I just want you to know that these will not be dutiable goods. These are definitely or prohibited goods, yeah? And then section 135.1e deals with goods, people who deal with goods with intent to defraud or evade duty or the applicable charges on those goods. And then you also have denies, people who deny having goods but is later found with them. So this is an example of what's going to happen in the airport if you come out with, say, 2 liters of liquor. I think it's pretty common knowledge that Malaysians, when we travel, we can only bring back 1 liter of liquor, right? 1 liter of maybe a bottle of whiskey or something like that. So imagine carrying 2 and you are supposed to declare 1, but you did not. And this is how you get caught under that provision. And then there's also a category for fraudulently evading duty or prohibition. Okay, so what are the penalties for smuggling offences? Smuggling offences relate to those who directly deal with those goods. So usually the fine or the imprisonment term is higher than those who are making incorrect declarations. The reason why being, not everybody can make a declaration to the customs department. So usually declarations or the usage of the system created by customs department is very limited to those who register with the customs department, like a forwarding agent. So because a forwarding agent do not own the goods, they are basically just doing a job for someone else. So they are declaring goods that belong to someone else, that is being sold to someone else, or that they don't even own. So that is why the penalties for the offences under section 133 are usually lower or more lenient than the penalties for section 135. So the penalties for carrying dutiable goods, wherein these are the goods where duty can be calculated on the things that come in. So for the first offence, it's usually a fine of 10 times to 20 times the duty payable on those goods, or jail of up to 5 years. For a repeat offender, the fine can increase to 20 times to 40 times of the duty, or jail up to 7 years. As far as I can remember, these provisions have actually been, again, it has been revised and it has become a more severe punishment, because I do remember a time where the fine was actually 10 times the value of the goods, or 1 million ringgit, whichever is the higher. But now it seems that the fine has marginally increased to 10 times to 20 times, and then 20 times to 40 times for a repeat offender. So do keep in mind that the law is constantly evolving. It is going to punish you heavier, and most of the times this is being done because existing punishment do not deter people enough from committing these kind of offences. So because they see the rampancy of the offence, that's why they keep revising or giving higher punishment for those who commit these crimes. So in terms of penalties for some goods which are not dutiable but also not prohibited, but these are goods that are not subject to duty but still have breached some sort of custom law. So maybe these are not unlawful goods, but maybe they need a permit to be brought in. So because they are not illegal, but you don't have the permit to bring them in, they are still considered uncustomed goods. The offense for this, the punishment for this is fine of up to 2 times the value of the goods, or 10,000 ringgit, whichever is higher. You will notice that because these goods are not, so unlawful or so uncustomed, there is no imprisonment for any offences under this. If you are being charged with this kind of goods, carrying uncustomed goods, there will be no imprisonment here. And then you have offences or the punishment for carrying or importing prohibited goods. So this is similar to the first one that you saw. I will just move back the slide. You can compare it. This is similar to dutiable goods. So if you can see, it's the same, 10 times to 20 times, or up to jail up to 5 years. And then for the repeat offender is similarly the same, 20 times to 40 times the duty, or jail up to 7 years. So it's about the same. When I say that the law is always changing, this Customs Act that I'm referring to here is actually updated as of 2023. And before that, prior to that, we never used to have penalties under the Customs Act specifically for that identifies cigarettes and intoxicating liquor. It used to be general. So cigarettes and intoxicating liquor can come under uncustomed goods, which means they're supposed to fall under the previous slide. But now the law has slightly changed. They have actually made direct mention of cigarettes and intoxicating liquor within the act itself. So as you can see, I will just move through. The first offense is fine of 10 times to 20 times of the duty, or jail between 6 to 5 years. So there is a minimum jail sentence that applies, and if it's provided that 6 months to 5 years, meaning 6 months, which is the shortest period, is the minimum jail sentence. And once someone is caught or found guilty for an offense under cigarettes and intoxicating liquor, you must be punished with imprisonment for 6 months and or a fine. So this one is referring to cigarettes and intoxicating liquor. The next slide we will go on to absolutely prohibited cigarettes and liquor. So there is a difference between cigarettes and liquor that are dutiable, which are those that you can buy and consume commercially. So cigarettes like the Marlboro, Dunhill and all that, these are dutiable cigarettes which you can buy from 7-Eleven or KK Mart or any kind of mart that you go to, you can find them. So the next slide, we're actually going to look at cigarettes and intoxicating liquor that is prohibited, which means you are not allowed to bring this in to Malaysia. And even if you bring it in, it doesn't become dutiable. It is straight away prohibited. But there is not much difference in the jail term or in the fine, although it's prohibited or dutiable cigarettes and liquor. So now moving on to those were the offences that can be found, or the most common offences that we can find under the Customs Act. Now we'll move on to the forfeiture proceedings, which involves the goods that were seized before somebody is charged with an offence. The goods will be seized, and then while we have seen what happens during the charge and what are the potential penalties that someone can face, now we will go to the forfeiture proceedings, which deals with the goods that were seized in the first place. Okay, so section 127 of the Customs Act is a provision that provides for mandatory forfeiture of any goods that have been seized. So what section 127 states is that an order for the forfeiture shall be made by the court before which the prosecution with regards thereto has been held, and an order for forfeiture of goods shall be made if it is proved to the satisfaction of the court that an offence against this act or any regulation made thereunder has been committed, that the goods were subject matter or were used in the commission of the offence. So by reading this term, you can see that there's a twofold requirement here, which is it is proved to the satisfaction of the court that an offence against this act has been committed, and so it must be both, it cannot be either one, and the goods were subject matter or were used in the commission of the offence. And the important part here is the next sentence, which is notwithstanding that no person may have been convicted of such offence. So what this tells you is that regardless of whether somebody is found guilty for any sort of customs offence, either under section 133 or section 135, regardless if anybody has been found guilty for any offence, order for forfeiture shall be made. So this is in terms of forfeiture where prosecution has begun. Now let's look at forfeiture for goods that have been seized but no prosecution has been proffered by the Customs Department. So this is provided for under section 128 of the Customs Act, which clearly provides that if there is no prosecution in regards to any goods seized, such goods shall be taken and deemed to be forfeited at the expiration of 30 days from the date of notice of seizure, unless before such expiration, which means before the 30 days from the date of notice of seizure, a claim has been made to such goods, or a written application has been made for the return of such, or such goods are already returned to the owner or to anyone who claims it under paragraph A or B. So what section 128 provides for is that if there is no prosecution, the seized goods are deemed forfeited after 30 days unless a claim or an application is made or the goods are returned before the 30 days. So what this means is if no one is prosecuted, the goods will automatically be forfeited after 30 days unless someone claims for it within time, which is the 30 days we mentioned. Okay, and then section 128 subsection 2 provides that a person claiming to be the owner or saying that the goods are not liable for forfeiture may give notice in writing to the Customs Department or to the officer who seized the goods. Okay, what the owner needs to do now is, if nobody has been prosecuted, it is going to be almost 30 days since the goods were taken from my premise. Okay, I own a warehouse. It has been 30 days since someone took this out. It is going to be 30 days. There is no prosecution. I have not been investigated. I have not been charged in court. What can I do now? So what I can do now is, as if I claim to be the owner of the goods, the owner must formally tell the customs in writing that the owner is claiming for the goods and saying that the goods should not be forfeited. Because what happens in section 128 subsection 1 is that if no claim is made, I will move back the slide for you to see the wordings. Okay, it shall be taken and deemed to be forfeited, right? So if no claim is made, it is automatically deemed to be forfeited. Okay, and then let's move on to section 128 subsection 3 of the Customs Act. Once an owner or somebody who purports to be the owner makes a claim in writing, what happens after that? So this section 128 subsection 3 talks about that. If a claim or written application is made within 30 days and there is still no prosecution, the senior officer must refer the matter to the Director General. So Director General is the higher officer who is capable of making the decision on whether to release these goods or not. Okay, then now that a reference has been made to the Director General, section 128 subsection 3A, subsection A of the Customs Act says that the Director General, once he sees that somebody, one of my officer, has given me a letter where it shows somebody is claiming for these goods. Now, as a Director General, what should I be doing? The Director General may then direct the goods or the sale of the proceeds or security to be released. So, the Director General can decide to release the goods, the money from the goods, if it was sold before. According to section 115, it can be sold. So the money that they sold, they have to keep it. They can't forfeit it or they can't deem it to be forfeited if a claim has been made. Yeah. So the Director General can now decide whether he wants to release the goods if it's not sold. If it has been sold, whether to release the money to the owner or any security that was paid for the goods. He can decide to release either any of these. Okay. The other option if he does not feel like he wants to release any of it, he does not want to release the goods, if the goods were sold, he does not want to release the money that they got from the sale, and he does not want to give any security back to the owner. So what the DG can do now, the Director General, pursuant to section 1283A subsection B, can direct the matter to be referred to a first class magistrate for a decision. So then a reference is made to the court. So a permohonan jenayah is made to the court. In the magistrate's court, it's usually called permohonan. So basically what they are doing is they are making an application to the court to decide on the status of the goods, whether it can be forfeited in the event an offence has been proven, or whether the owner can prove that no offence will be committed or has been committed in terms of these goods, and the goods can then be released to the owner. So once the procedure has gone to the court, to the first class magistrate, then section 128 subsection 4 will start applying. The magistrates will summon the claimant or the person who made the claim to the Customs Department saying that they are the owner. So the magistrate will summon that person, then they will have an inquiry and they will hear the case. It's like a full trial. And if an offence is proved and the goods were linked to that offence, the court can order forfeiture. If not, the goods, the proceeds of the sale or the security may be released back to the person. So that is section 128, which gives for the procedure forfeiture if there is no prosecution initiated by the Customs Department. So section 129 then talks of the goods or amount forfeited may be refunded to the owner. So what section 129 talks about is that there's already a deeming of forfeiture pursuant to section 128 subsection 1, or there's an order from the court that the goods be forfeited. So what an owner can still do, and an order for forfeiture is not the end. So what I'm trying to say is the owner still has a recourse. What they can do is they can make an application to the Director General, who will then make another application to the Minister. So the Minister here we're talking about is the Minister of Finance, because the Customs Department falls directly under Minister of Finance. So the Director General can make an application to the Minister for an order that any goods seized under this Act or any amount under section 115, whether forfeited or taken and deemed to be forfeited under section 128 or section 131, to be delivered or refunded to the owner. Okay, so it is not the end all be all if the court orders for a forfeiture. As the owner of the goods, there is still some sort of recourse that you might want to pursue, which is an application made through the Director General to the Minister of Finance. Okay, so these are the process or the procedure for offences under the Customs Act and forfeiture of the goods that were seized under the Customs Act. Now we will go through some of the case studies that will explain the presentation or the facts that you have been presented with before this. So this is a case of Keng Soon Finance Berhad. This is a decision of the federal court. So the brief facts are provided here. Customs officers set up an ambush and blocked the road, but the motor car that they set up to ambush drove past the barrier, crashed into a ditch, and was abandoned with dutiable goods inside. So eventually no one claimed the goods, although the applicant, being Kangsoon Finance, later claimed ownership of the car. So what I assume here is that the car was under a hire purchase and they wanted the car back, right? Because nobody is paying for the money, they can at least get the car back. And so they made a claim for the car or the vehicle, and they were summoned for a forfeiture inquiry subject to section 128 subsection 1. Okay, and then it was before the magistrates court or the sessions court. So there was a proceeding before the court, and initially the court said the car has been used in the offense of conveying dutiable goods, and they found that an offense had been made, and they ordered the forfeiture because the vehicle was used in the commission of the offense. Then this went up all the way to the federal court, and the federal court actually stated that if the court is satisfied, after considering the whole of the materials before it, an offense under the Act has been committed and that the goods were subject matter or the vehicle was used in the commission of the offense, then in that event, but not otherwise, it is mandatory for the court to make an order for forfeiture. So because this went all the way to the federal court, this remains good, it remains unchanged. So what happens now is any court that is faced with whether they should order a forfeiture or not, they can refer to this case, and what happens is they will say, oh, if I'm satisfied an act has been committed and that these goods were the subject matter, or if I'm facing a forfeiture of a vehicle, if this vehicle was used in the commission of the offense, then I must make an order for forfeiture following the case of Kangsoon Finance. So then Kangsoon Finance was in 1981, which is a really old case. But since it's good law, it's still applicable until today. And we will see the application of this case also in Public Prosecutor versus Nasrun Effendi, which is a later case in 2008. So in this case, the facts are provided here. The Magistrates Court ordered that exhibits, including a boat named KM Slam, be forfeited to the Royal Malaysian Customs Department pursuant to Section 127, subsection 1 of the Customs Act. The respondent filed an appeal and it was not yet heard, but while waiting for the appeal to be heard, the applicant also made an application under Section 407 of the Criminal Procedure Code seeking for the release of the boat on a court bond or under a court bond. So because the previous court or the lower court had actually ordered for the forfeiture of the goods, what happened here was Section 407 could not be applied because there was no stay on the order of the lower court. So that means it is considered to be forfeited until the appeal is heard. So on appeal, what happened was the court held that provision 127 regulates the manner in which a particular thing which formed the subject matter of a charge can be forfeited. Therefore, the High Court held that it had no other choice but to follow that manner which has been fixed under Section 127. In the circumstances, the magistrate had acted properly when he ordered the forfeiture of the boat KM Slamat when the respondent pleaded guilty on the charge. But you might want to realize that earlier during my talk, I told you that notwithstanding an offense or any person has been found guilty of an offense, right? So notwithstanding, you can still forfeit. But here it was made worse because they actually already pleaded guilty. So because you already pleaded guilty on the charge, it was automatic that the order for forfeiture had to be made by the magistrate. And then we come to this case, quite recent, 2017, Chong Yin Kim versus Public Prosecutor. In this case, the facts were that appellant was charged under Section 135, subsection 1, subsection D, for knowingly possessing prohibited goods, namely liquors and beers. At the end of the prosecution's case, the trial judge acquitted the appellant without calling for defense, despite the court ordered that the seized goods be forfeited. And then the appellant ordered appeal against the forfeiture order. So in this case, in a prosecution from the Magistrates Court, it went to the High Court, and the High Court held here that, as it can be gathered from the above case, central to the decision making by the court under Section 127, is the court's satisfaction that both of the conditions therein have been proved. Conversely, if the court is not satisfied that any or both of the said conditions have been proven, the court cannot order forfeiture of the seized goods. So I will just, if you can recall earlier in the presentation, Section 127 said two things. that has to be satisfied, which is the court must be satisfied an offence under the Act has taken place and that the goods or the vehicle was used in the commission of the offence. So what the court said here is that the court must be satisfied that both of these things have happened. If either one is not proven, either that the goods were not part of an offence or the goods were not considered to be an offence under the Act, or alternatively, if the goods or the subject matter or the vehicle was used in the commission of the offence. So if either one of these is not satisfied, the court here in this case held that the magistrate cannot order forfeiture of the goods. It has to be conjunctively, both of the requirement must be satisfied. Now we'll look at the case of Ocean-Borne Agency Sdn Berhad versus Public Prosecutor. Here, the appellant was acting as an agent of a vessel and he was charged for making an incorrect declaration in the ship's manifest, which did not accurately reflect the contents of the container. If you can recall what I just said earlier, if you are acting as an agent or if you're acting as a forwarding agent or a shipping agent, you cannot see what is inside the container before you make a declaration. You will always rely on the documentation that is provided to you by the importer to make these declarations. Okay, so the trial court in this case, in Ocean-Borne, acquitted the appellant but still ordered for the forfeiture of the goods under Section 127. The appellant appealed against the forfeiture, arguing that no offence under the Act had been proven to justify such an order. And luckily for the appellant in this case, the High Court actually agreed with them. So the High Court agreed that since no offence had been committed in respect of the goods, and the question of forfeiture does not arise under Section 127. So here the judge held that the goods should have been released and that he will allow the appeal against the order forfeiture. So please do not mistake this to the earlier part where I said notwithstanding, no person has been charged with an offence. It doesn't mean the same thing. What I'm trying to say, even if a person is not charged, they have been acquitted, or they were charged and they have been acquitted and nobody is found guilty, the court can still order forfeiture as long as it's satisfied that the goods itself was subject matter of an offence. Here, because there has been no offence that was created in respect of the goods, that means the prosecution in this case had failed to prove there was any offence under the Act. And because they had failed to prove there was any offence under the Act in respect of the goods, the court said the question of forfeiture does not arise in this appeal. Okay, this is a very recent and interesting case regarding incorrect declarations. So this is Public Prosecutor versus Trans-Coastal Sdn Berhad and another appeal. So this went all the way up to Court of Appeal. The facts of this case is here. Trans-Coastal, being a shipping agent, declared containers as machinery based on shipper information. So shipper's information is usually coming from the importer. Okay, the customs inspections later found the containers actually contained beer. The company was then charged for making false declarations under Section 133 of the Customs Act. So the issue arose here is that, is a shipping agent liable for false declaration if it relied on information provided by the shipper and could not verify the contents? So the court in this case very interestingly found that despite Section 133 being a strict liability offence, there are still valid defences that exist for a shipping agent. So in this case, a valid defense existed where the agent had no knowledge and could not reasonably verify the contents of the container. So the Court of Appeal in this case accepted that containers were sealed by the shipper, the agent relied on the shipping instruction in good faith, and it is industry practice that agents do not verify contents. So the sealed containers can only be broken by customs officers during an inspection. So a shipping agent has to make a declaration. They can only rely on information or on documentation that is provided by a third party. In most cases, it is either the shipper or the importer. So in this case, very recently, the court decided that there was no criminal liability for the agent. The acquittal in one case, in one appeal was upheld, and the conviction by the High Court in another appeal was set aside. So basically, what that means is the Trans-Coastal was free to go. They did not commit any offence. The court held that the agent acted bona fide, which means in good faith, and they acted reasonably. So the key takeaway of this case is that even in strict liability offences like wrongful declaration or incorrect declaration under Section 133, liability may not arise if the accused genuinely had no knowledge and no ability to verify the truth of the declaration. So now we will look at some of the defenses in smuggling offences, and I will make very quick examples. I will show you very quick examples which can be clearly seen through the case study that we will do later on. So some of the defenses in smuggling offences, as lawyers, we know that there are various defenses available to an accused in the course of a trial. Even for smuggling offences, there are about 7 types of smuggling offences that is provided for under section 123 between subsection 1A to 1G of the Customs Act. So elements of a charge will vary according to each subsection. So there is no standard element to prove, with the exception of the status of the goods, meaning it must be proven that the goods were uncustomed. Okay, it must be proven that the goods were either uncustomed or prohibited. And this again the burden of proof remains with the prosecution throughout the trial. Okay, so there is nothing for you to disprove until the prosecution has proved its case on a prima facie level. If any subsection refers to knowledge of the accused in either one of the section 135 1A to 1G, if any of these subsection refers to knowledge of the accused, meaning there's a usage of this word knowingly. Okay, the element of knowledge also must be proven by the prosecution to secure a prima facie case. Only after a prima facie case is proven, defense will be called. So as for an accused, various defenses are available for any of the 7 charges under section 135. This includes but not limited to claiming that you have no knowledge, claiming that the status of the goods have not been proven by the prosecution. There might be some gaps in the investigation or incomplete investigation. There might be procedural irregularities, such as irregularities in a valuation report or a chemist report. Okay, then a defense could also be exclusive possession of uncustomed goods or prohibited goods cannot be proven. And sometimes in an entirely weird situation, there can also be a wrongful arrest, or you are not the right accused, or you are just purely an accused might be a victim of circumstance. So basically they have been at the wrong place at the wrong time. Okay, so we will look at those defenses in the context of some case laws here. So in this case of Wolfgang Petzold versus public prosecutor, the accused was charged under section 135 1D and 1E of the Customs Act. So in order to secure a conviction, it must be proven that the accused had knowingly possessed. Again, this comes back to the question of knowledge, because they have used the word knowingly here. So they had to prove 2 things. 1, that the status of the goods being uncustomed or prohibited, and 2, the issue of knowledge. So it must be proven that the accused knowingly possessed of prohibited goods and he knowingly was dealing. In this case, he was selling. So dealing also sometimes could mean selling uncustomed goods. So the appellant in his defense, narrated how he had obtained all the impugned goods referred to in the charge. According to him, the customs authorities at the Johor Causeway checked those goods and allowed him to bring them with him in the bus when he was traveling as a passenger. Interestingly, the appellant maintained that he did not know the laws of this country. He came here as a tourist from Germany through the causeway, and that having brought the goods without any ado from the customs at the Johor, it was unfair and improper that he should be punished for what might have been negligence of the customs officers themselves. The judge here held that the learned president did not adequately consider the import and significance of the word knowingly in the definition of the offence under section 135 subsection 1D, and did not direct his mind at all to the absence of cross-examination of the appellant and his witness by the prosecution to the quantum of proof which the law requires the accused to rebut. So this is in terms of section 135 1D. The court on appeal held that the lower court did not appreciate the evidence before them. And then moving on to the section 135 subsection 1E, which is the second charge, the court said that in order to convict the person under this charge, mere knowledge on his part that the goods are or prohibited is not good enough. The subsection further requires that there should be an intent to defraud the government, and that the duty payable or to evade any of the provisions of the Act or to evade any prohibition applicable to such goods. So in this case, because the judge found that the prosecution had failed to prove the elements of the charge, he allowed the accused appeal and ordered that the order by the lower court set aside, and he let go of the accused. Okay, we will move on to the next case of was it Lalaki Krishnan and another. So it's a fairly new case. Why I picked this case is because there are so many things that went wrong in this case, which are all defenses that you can use to defend a charge under the Customs Act. So in this case, the accused was charged under Section 135, subsection 1, subsection D. The magistrate court found that the prosecution failed to establish a prima facie case. So on appeal, it was held that where the prosecution's own evidence shows that the investigation only focused on the respondent operating without a valid license and not finding the uncustomed goods, the evidence is weak to prove that the respondent knew such goods present in the premise. So basically, the judge here is talking about gaps in the investigation. So they did not, the customs officers or the prosecution did not prove that or did not conduct proper investigations before the charge was brought to the court. Okay. Then the court also held that for offences under Section 135, subsection 1, subsection D, the prosecution must first establish knowing possession of uncustomed goods before any statutory presumption of knowledge may arise. So subsection 135, subsection 2 is the one that provides for presumption. But however, in this case, the judge said you have to prove the offense first before relying on the presumption. Then the judge also in the same case said that the burden lies throughout on the prosecution to prove at the prima facie stage and beyond reasonable doubt two essential elements. First, that the accused were in possession, and second, that such possession was accompanied by knowledge. Possession in criminal law requires proof of control and conscious knowledge and cannot be assumed simply because the accused was found at the premise. So this is again what I'm saying. You could be a victim of circumstance and that you're just there and the goods happened to be there and it was caught. And then you were charged with an offense. So applying this principle, the magistrate took into account the evidence that several boxes were sealed and had not been opened, and therefore they could not have had knowledge about the contents of the boxes. So these will be available on the slides later on, which will be uploaded to the website. But because we are running short on time, I think I will just end the talk here, and I think we can take some questions from the audience. Aaron?
Yeah, thank you for your insights on today's topic. We will take a few questions from the Q&A chat box and also some other questions. Now, the first questions, are there any recent trends or shifts in enforcement priorities that businesses should be aware of?
Okay, interesting question. Businesses are not exempt from enforcement in smuggling cases. Recently, somewhere around before COVID, around 2019, there were news reports that a business owner can be charged for smuggling carried out by its employee. So I am aware of this case in Kota Kinabalu where a business owner, the managing director, was charged with smuggling rice, Vietnam white rice, under Section 135, subsection 1, subsection A for importing prohibited goods. So it is not completely impossible for business to be charged together with its employees.
I see. Okay, now the next question. At what stage does a customs investigation typically escalate from seizure to prosecution, and what factors influence that decision?
It is very important to note at the beginning point of any investigation is always reasonable suspicion. And reasonable suspicion can arise at any stage of the transaction. It can arise even before the goods are imported into the country. It can arise during transshipment. If you can recall, I said earlier in the talk that there is a time limit within when a container comes here and a declaration must be made. So if you do exceed this time limit, automatically there's a trigger on the suspicion. And as soon as some documentary lapses are present during any of these checks, it can escalate quickly from seizure to prosecution. However, there are a wide range of factors that determine whether the prosecution will be carried out. So as you have heard earlier in the talks, goods that are seized in respect of which no prosecution has its own procedure for forfeiture.
Okay, the next questions. We have heard about you talking about agents charged for falsifying declarations. Now, the next question is, I'm just the driver or the warehouse owner and not the importer. Can I be arrested and charged?
A simple answer for this is yes. Anyone involved in moving, storing, harboring, concealing, keeping, dealing, handling any goods that are suspected to be prohibited or uncustomed can be charged.
Okay, the next question. If someone is charged and acquitted, will they automatically get the goods back?
No, not necessarily. A forfeiture can still happen in certain situations, even where there are acquittals, as long as the two criteria I mentioned earlier in the talk is satisfied, namely, the judge is satisfied an offence under the Act has been committed, and two, the second criteria that the goods were subject matter of the offence, or in case of any vehicles, the vehicles was used in the commission of the offence. Okay, there's a question here from the audience. When will the government impose the ban on importation of vape and vape pods? So this is still up to discussion in the parliament. We do not have any news on this yet. However, we will keep you updated through our newsletters or through our articles if there's anything interesting that we can update you all on.
Thank you. Sorry, everyone, due to time constraint, and it's already 4:30 now, I believe that we have to stop here. And I also know that there are some other questions that the audience have already asked. If we haven't answered your questions, you can drop us an email or even get a complimentary legal consultation later. Now, before we conclude, I have a few announcements to make. Our next talk is on the 8th of April 2026. The topic is Strengthening Your Contracts in Uncertain Times, Understanding Force Majeure. Now, in view of the current global tension, this is a talk that you will not want to miss. You can also scan the QR code on the screen to sign up for any of our online talks. Now, secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow us or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. And fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference such as Zoom or Google Meet. Please fill in the form on our website. The link is posted in the chat box, or you can scan the QR code on the screen. To our guests, thank you for joining us today. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.